and we are on. I want to welcome everyone to our in this post-COVID era fairly informal workshop conference event on mandatory human rights due diligence. The workshop is framed around the contributors to a book that hopefully will be published in fairly short order. My role here, just very briefly before we get started, is to sort of introduce us all, frame the issues a little bit, get us. I'm sort of the opening act, but you're all waiting for the really interesting stuff to come. So kind of bring you into the mood and the spirit of things. And then each of our presenters will discuss what will become in a much more elaborate form their own contributions to this joint effort. So we're going to be talking about due diligence, of course, and due diligence is rapidly becoming a powerful tool in efforts to embed human rights and sustainability norms law in the activities and decision-making processes of economic actors, primarily corporations, increasingly financial institutions, and also increasingly other entities as well, the scope of which remains open-ended. Due diligence, of course, is also a central element of the UN Guiding Principles for Business and Human Rights, and especially its second pillar framework, the corporate responsibility to respect human rights. Its driving idea has been to align corporate activities with international normative human rights and now increasingly sustainability standards, and in the process addressing what had motivated the UN Guiding Principles Project in the first place, which was to address governance gaps associated with globalization and in promoting economic activity that treats all parts of the global value chain with equal respect. Now, that brings to the center a number of terms that before we began, certainly before the start of this century, had one meaning, the meaning of which have now become central to the problem and the search for solutions around which this project is built. And of course, we start with the big term. And so I'm going to introduce the terms to get us oriented and their ambiguities. The central term, of course, is due diligence. And at its most general, of course, due diligence is a process that involves risk and compliance checking, conducting investigations, reviews, or audits to verify facts and information about particular subjects. At its most general, it doesn't require you to do anything or to make a decision, but it is meant to be a way of enhancing the factual basis around which you can apply other things, normative standards, expectations, objectives, and the like. Due diligence can be used, of course, in any direction in the context of the process of legalizing business and human rights. It has a very particular normative meaning. Now, in business, of course, due diligence is the investigation or exercise of care that a so-called reasonable business or person is normally expected to take before entering into an agreement or contract with another party or enact with a certain standard of care. Due diligence, of course, now means more than that, the investigation and exercise, not just for these private purposes, but increasingly to meet public objectives. All of this, of course, revolves around risk. And we talk about a number of risks. Risk involves uncertainty about the effects and implications of an activity with respect to something that humans value, and often focusing on negative or undesirable consequences. And there are many definitions have been proposed, but most of them involve uncertainty. Due diligence is meant to provide the facts necessary to reduce uncertainty and then to guide actions in accordance with whatever normative system or objectives are motivating or that drive the process. Over all of this, of course, is a notion that at one point was particularly marginal, but now has kind of moved to the central sphere of both policymaking and to some extent business conduct. And that is the fundamental principle of prevent, mitigate, and remedy. Prevent, of course, means to avoid adverse effects, and remedy. So it is meant to, it is something that you do beforehand. Remedy is at the other end of the spectrum. It's something that's done after damage has been caused. And so you've got the two bookends of the policy within which we're going to put in due diligence in the context of risk. One is prevention, which has tended to be a state-based public and administrative policy, to some extent a business policy, and then remedy, what happens after the damage is done, and then you make it as right, or you compensate, or you make it as right as you can to rectify. In the middle, and this is where things get interesting with respect to current efforts to mandate human rights due diligence. In the middle is mitigate, which involves an ongoing process and requiring adverse effects to be reduced in severity or moderated. And we do that through the directed use of facts, that is, of due diligence, to avoid remedy and to move closer to a prevention model. And it's aligned, therefore, with compliance. Notice this is a universe of terms that come together that shape the project of mandatory human rights due diligence. Mitigation is, of course, closely aligned with compliance, which is the state of being in accordance with established guidelines or specifications, or the process of becoming so within markets cultures that had tended to be aligned to markets expectations and confirmed or disciplined by decisions of market participants to engage or not engage in transactions. Increasingly, compliance has moved into a public law function that is to comply with not merely technical specification, but public law-based and normative objectives around the notions of prevent, mitigate, and remedy, involving the reduction of risk through the targeted and very specific forms of the development of standards and systems of due diligence. So this is sort of what we're going to be talking about over the course of the day, and we're going to see this one can already see the complexities here, and we're going to get at this from a variety of different perspectives. And it is in that context, of course, that it's our great privilege to bring together some of the globe's leading scholars. I am just so thrilled to be able to work with the folks who have contributed to this work, to consider more closely the operationalization of due diligence as it has come to be approached by states, by the international community, and business. Our program, just very briefly before we kick off, our program is in two parts. We have a shorter morning program that has now begun and will last to about 12:30. And then we have an afternoon program that begins at 3. And I know that there are many of us that are joining from all parts of the world. We know that this can be fairly difficult. We're recording the program, and we will make it available in short order afterwards. Each one of our speakers will introduce themselves to try to make this a little more efficient, and we'll talk briefly about their work, maybe 15 minutes or so, leaving some time for questions. We'll have 5-minute breaks between speakers. This morning, we will have Shelley, Marshall, and Justine Nolan speak to sector and thematic due diligence laws. Lucas Roorda speaking to human rights due diligence and foreign liability claims. Birgit Spiesshofer speaking about the supply chain due diligence law in Germany. Carola Glinski will speak about the relationship of human rights due diligence to civil and tort law, and I'll speak very briefly about human rights due diligence in the UNGP. And without further ado, it is my great pleasure to introduce Justine Nolan, who will now speak. Thank you, Justine.
Thank you. Thank you so much, Larry. And thank you, Larry and Claire, for organising this. Much appreciated. I'm presenting a paper that has been written on behalf with myself and Professor Shelley Marshall. Shelley is based at RMIT in Melbourne, and I'm based at the Australian Human Rights Institute at UNSW in Sydney. And I apologise in advance that my time is going to be a little bit short, abbreviated, because still 3 years, post-COVID, I got it all wrong. So I'm going to only speak quite briefly about the paper and hopefully give you enough that we could have Q&A, because I think that's probably more useful. And then I will cede my extra time to Lucas. So I'm just going to try and share screen on this. 1 second. Okay. So as Larry mentioned, what we were looking at is trying to draw out any lessons from human rights due diligence that on a sort of a sectoral basis. And what we know, what Larry was talking about, what we've seen with, a lot of the due diligence guidance and laws that have come out is that they're quite broad at an institutional level, like the type of guidance that you see in the UNGPs and the broad OECD due diligence guidance. It's good in setting frameworks. The question is, how useful it's going to be as we move along. And what we're trying to do in thinking about this is that we're trying to think about what will make human rights due diligence effective. So to me and to us in some ways, what we're seeing is that we've gone through this phase of something sort of being the shiny new thing in business and human rights. And this is going to be the next thing that, solves all the problems, whether it was social audits, then it was reporting, greater transparency, and now we've got human rights due diligence, and it's sort of like, the thing that's going to solve a lot of problems in operations and supply chains. What we're seeing with these really broad guidance is that the form and implementation of human rights due diligence is open to multiple interpretations. The UNGPs and Ruggie in particular, said that this was necessary because we need it to be flexible, we need it to be adaptable, that companies need to be able to, move and be agile with it. At the same time, this makes human rights due diligence quite amorphous and in danger of, I think, susceptible to perhaps not giving us that precise guidance that perhaps where we're at too. And what we also are seeing is that as it's starting to emerge, there's just slight variations, or it's going to be in a different form in the new national and regional regulations that are coming. So the fact that we've got human rights due diligence embedded in laws is a significant step forward. I think that's a good thing. But we also have to think about what is it that we're embedding in laws? What do we actually want business to do? How is government thinking this is going to be an effective tool in curbing corporate human rights abuses in supply chains? And what happens when it's a slightly different format, whether it's national, regional, or international? So what we're trying to do with this paper is say, let's have a look at some of the human rights due diligence laws that are more sectorally based. And what is it about them that there might be some lessons that we can learn? So the ones we're not looking at, we're not in this paper saying sectoral approach is the way to go, and the initiatives we're looking at, these are the best things that's out there. Rather, we're sort of saying here are the downsides of having a really broad approach, and then what can we get from these narrower approaches? So the question that we're sort of looking at is, what guidance can we get from a narrower focus if we're crafting human rights due diligence in laws and policies? Is there something from these narrow approaches that would be effective? And generally, when we've looked at the narrow approaches, there's sort of different ways of looking at it. One is that they've been crafted to apply to an entire sector, it might be fishing or horticulture, and others where they've been more product specific within a sector. So they are sector focused, but they can be quite narrow in the way that they're crafted. So the way that we've thought about this is that we've tried to contrast it a little bit with this broader what we're calling cross-sectoral approach, which is shorthand for sort of the UNGPs type approach, where you've got a big overarching guidance of what human rights due diligence should be. And and they're really obvious, the issues that might be the limitations of that. It might be difficult to draft meaningful requirements for companies in each sector. Are they all going to apply across? Sometimes when guidance is so broad, it actually can lead to more of a tick the box approach, because companies are it's easier to identify a risk, monitor a risk. They're quite easy things to do without that level of specificity. It's difficult as an outsider to monitor and track implementation and try and determine what effectiveness looks like if the guidance is so broad. And we also think that when it remains broad at a high level, it's probably more likely to encourage companies to do more of the same, which in this industry has tended to be a lot of social audits, which is about a US $300 million industry at the moment and still growing. We know the limitations of those. And so if human rights due diligence isn't going to encourage a different way or a more transformational way of thinking, then perhaps it's going to have more limited effectiveness as a tool for change. So these are what we looked at, and I won't go through all of them. And something like the OECD guidance, that's the sector-specific guidances that we've seen on agriculture or finance, etc., as opposed to the broad one. Now, the EU directive is up there, and I'm sure many of you would go, oh, isn't that what would fall into that cross-sectoral approach? It appears to be cross-sectoral, but it's in fact sort of hybrid in the way that it's dealing with human rights due diligence, because it provides for some sectoral approaches in terms of the coverage of the directive, sectoral guidance, and industry and reference to industry schemes and multi-stakeholder initiatives. It has elements in it that allow state authorities to sort of specify how they're going to fulfill their due diligence obligations, and particularly encourages the issue of sector-specific guidance in relation to that. It also makes reference to industry, as I said, industry schemes as well. So although it's set up as this sort of broad, a little bit of an amorphous approach as well, within it, there are elements of a sectoral approach. So what we're trying to look at is pull those out and say, does this enhance it? Does it detract it? What does this make in terms of trying to understand if this might be effective, if it comes into play? Some of the other ones that are more sort of traditional, what you would easily identify as sector, we looked at the conflict mineral sector, because there are three there that you can contrast very easily. The Dodd-Frank Act, which was really the first in this area, the EU mineral laws, and the Chinese mineral code. They're all quite different, and they all have, limitations in relation to them. But they are very focused on, a very particular issue and problem within that sector that they're trying to address. And they're using different levers to do that. And so what we're trying to do is draw some of those out. And then finally, we were looking at a third group, which is we're really using the Dutch approach within this to say, what about if we're getting guidance on human rights due diligence from an institutionalized multi-stakeholder initiative? And from this, we've looked at some of these agreements that preceded the Dutch Child Labour Act, which were focused on developing a multi-sectoral approach or a tripartite approach to human rights due diligence. And in particular, we looked at the textile agreement in relation to this. So what do we find out? Basically, three main points, and I'll stop after these three main points, next three slides. The first is that what we've seen as a commonality is that some of those that we've seen a consistent reference in some of them to making reference to internationally recognized standards. So even though they're sector specific, they are then drawing on something above it. And trying to make consistency, because one of the dangers we noticed is that if we go with the sectoral approach, then all of these standards could be quite different. And so some of them are drawing on the broader standards. And so each of these particularly is there's often some reference to the OECD guidance in relation to it. The Dodd-Frank obviously preceded all of these done, but there's a provision in the Dodd-Frank that basically builds in the concept of due diligence by making reference to sort of national or internationally recognized due diligence frameworks as a way of giving credibility to what businesses are doing in relation to that. The second point is that some of them propose to sort of not always mandate, but make firmer a commitment to stakeholder engagement. So one of the things, I think the big missing pieces around human rights due diligence at the moment is the extent to which it will actually engage with stakeholders. And engagement, we look at difference from consultation. Consultation sort of might be companies dropping in and out, checking with something. Engagement, the idea is that it's a much longer term. So some of the provisions there of the proposed EU directive are trying to bring in potentially a more sustained approach to stakeholder engagement. And this was obviously very core to the Dutch responsible conduct sectoral agreements, where they were actually created by multi-stakeholder bodies. And we see this as a strength of a sectoral approach when they are sort of mandating a stronger agreement, engaged compulsory stakeholder engagement. And then finally, some of the ones, and we're seeing this progressively, have taken quite different approaches to the involvement of the state. And in particular, there's different roles for the state, potentially as either a body that has sort of established it and has some monitoring ability, or providing funding, which was the Dutch textile example. The proposed EU directive has sort of a role for the state as a supervisory authority. And then the example of the Uyghur law is where the government is providing very strong guidance and resources in basically, providing people with information, providing companies with, information, and civil society with information about, that might strengthen due diligence. So there's all different ways that a state might be involved in due diligence. And these sectoral approaches have taken slightly different options in relation to this. But we do see these three elements. So that's sort of the state, the stakeholder engagement, and the consistent reference to internationally recognized standards as a useful thing in looking at sectoral guidance in relation to human rights due diligence. So that is my very speedy take on the approach that we're taking with it. So Larry, I'm welcome any responses or questions in relation to that.
Well, that would be great if there are questions from anyone. I do have a question. I'm going to abuse my position, and that is the obvious one, I think, which is coordination and conflict, where there's a proliferation of these. You make a very strong case for the internal need for sectoral approaches, but what happens when these sectoral approaches all exist simultaneously within these ecologies of businesses, and they leak over each other? Is there going to be a conflict? Ought there to be a coordinating role somewhere? Or is this one of these things where markets-driven kind of regulation may ultimately sort all of this out eventually?
Yeah, I mean, there's been a lot in the business human rights field where we're just waiting for everything to sort itself out eventually, isn't it? Yeah. So I think with this, and it depends a little bit about how you think about the purpose of human rights due diligence, and these are different examples of guidance and laws and policies, etc. So where we reference that they make some they have some level of consistency with the overall approach of human rights due diligence. And most consistently, that's probably the OECD due diligence guidance, the broad one before it breaks down. Because that actually, I mean, although the UNGPs and the OECD are aligned, the OECD due diligence guidance provides more information, more detail around perhaps where this is heading. And I guess where we see the sector approach is trying to avoid just those big tick-the-box approaches and say, well, in this sector in particular, we know there are issues with supplier engagement or, wages, etc. And some of the OECD guidance, you see that specific reference in relation to the apparel industry. That's different from the minerals and stuff like that. And so I think there is, and so if we see that these policies are useful for companies in providing more practical approaches, that's where I think the sectors come into their own. But I think you're right in being wary about everybody going off on different paths and potentially everyone having different supervisory mechanisms around this. And so the question then is, should they just be providing practical guidance, or should they have an enforcement angle to it? And that, that's something that we're still sort of looking at. But I think that's the key, is what do you actually use the role of the state for in relation to it? But yeah. Don't know the answer.
Other questions? Lucas.
Hi, yeah, good morning. Thank you, Justine, for a very interesting presentation. Referring to especially the Dutch multi-stakeholder agreements, which, well, of course, I'm quite familiar with. I was sort of wondering what benchmark you use to sort of say that the stakeholder engagement has been properly arranged, because this is a point that actually my previous job I've been quite critical of the extent to which stakeholders get engaged in the entire due diligence process and not just like in the initial risk assessment. So I was wondering, like, what for you are the most important points at which stakeholders need to be involved, and how do we sort of like measure whether or not this is sufficient and accurate? Like, what's the benchmark basically?
Yeah, and I guess with these, we're not saying that we think these are all the perfect standard. We're sort of pulling out bits of it in relation to it. And so in an ideal world, human rights due diligence should actually be involving the stakeholder from the beginning in designing policies way before implementation. Mostly what we've seen in business and human rights field so far is that the stakeholder comes in sort of post the establishment of an operation, and often as a check and balance as opposed to sort of a co-design. And I think that's where we get to this point where often stakeholders are part of a consultation, but not engagement. And so for an engagement, we would see that if a business is designing it sort of, what it would be in terms of human rights due diligence, then from the very start, the way that it's doing that should be a reach out. There should be this multi-stakeholder approach to that. They're designing policies, that they're looking at it, and then they're also involved in monitoring and effectiveness. Now, none of the systems have that, at the moment. None of them have that holistic approach. But if human rights due diligence is going to be sort of any different from what we've seen in the past, then I think there has to be actually a way of mandating stakeholder engagement. And so one of the things we're thinking of is that easier to do on a sectoral basis when it might be easier to think about what particular input they have in certain sectors versus others, or does it make it all too complicated? Because you're not going to see it in any of the broad, it's barely even referenced in the UNGPs, really. And there's sort of, the discussion around stakeholder engagement, but it's sort of I don't read that as requiring it, really. So it's a good question. So I wouldn't say that we found an example or perfect example of it, but to us, we're thinking that to do something radically different from what's been done before would require businesses to actually change their approach and open up from the start. But you have to also see, there's a benefit to them in doing that. Why would they be doing it? Because they're actually going to be the design of a better policy. They're going to engage the stakeholders, they're engage the community, and hopefully would lead to less conflict. In some situations where we've seen, we've been not related to this research, I've been looking at something different where there was sort of a profit sharing agreement with an Indigenous community in South America. That was because they were involved from the start in designing it. And that's rare. But if we actually got to a point where that was a standard, maybe that would make a change.
Justine, if we can impose on you, I know you've got to go. There's a very interesting question from Andrea Schemberg. Thank you, Justine. Have you done any thinking about regulatory approaches that would not focus on due diligence overarching, but that would look at approaches to achieve the same goal as human rights due diligence, more refined, more detailed, and more aimed at specific problems? Rather than sectors, where human rights due diligence would be the means, but the legislation would make perhaps less overarching requirements?
Well, that's a very complicated question, Andrea. Nothing less than what I would expect of you. So tangentially, I think is the answer. So one example I'm thinking of is a business I was looking at where they had quite a radical approach to their supply chain, and they were sort of working directly with worker cooperatives. They'd cut out, the middleman in relation to it. They were being very transparent about their process. And this company had never heard of the UN Guiding Principles. They'd never heard of human rights due diligence. But some of the elements that they were doing, which was sort of a really engaged, long process with stakeholders in this partnership, then actually helped shape a government approach, which followed after their own work. So this was a company that was doing it because they thought it would be effective and they've got a purposeful approach to things. But it actually had nothing to do, at the same time, you know, the new EU laws on deforestation and stuff would apply to them, but it all happened tangentially around it. So that's something interesting to me, is around what drives that change. What are the drivers that make companies do that, other than like, you know, B Corp purpose approach type thing? What is it that makes it a more efficient system for them to do that? And then almost in a way, what I want to do is reverse engineer human rights due diligence into that. If that's such a good way, what is it that would feed into the human rights due diligence approach? So I think that's probably not the you know, full answer to what you're thinking, but that's what's going around in my head in relation to it. And we haven't, in this paper, we've been focusing more on regulatory approaches. And then I'll quickly, if you like, Larry, answer the question from Fiona.
Yes.
And Fiona has been part of the research team I've been working with for 3 years. Would Australia and other non-EU countries have to introduce a human rights due diligence law to meet international standards? Ideally, yeah, but at the moment, the international standards are a little bit all over the place. But if the EU law came in, I think that would be the default EU standard in relation to it. And so would people align with that? That would make sense. The question is, you know, is that going to be sufficient, or how it's interpreted? So I think that's where we're moving, and Australia is potentially moving that way, but slowly. But it would take some time, I think. And then the last one, Elena's question, where the UNGPs framework is still very new, does it make sense to start with mandatory human rights due diligence or soft measures? Well, I think that, I guess for me, the world has sort of moved on, not from the UNGPs. The UNGPs gave us a framework, but there's no need to go back to the sort of future and start there. I think let's start from where we're at, which is where we're seeing more mandating of transparency laws and human rights due diligence. That's the starting point, I think, now. The UNGPs provide us with that big picture, but the starting point is the law, but the law alone is never going to be sufficient. You've got to change corporate culture. You've got to change business practices. So the law provides you with a framework, but to me, the more interesting point is how you embed that in business practices, and that's law plus. Law plus what? Law plus culture, law plus social change, law plus pressure. And so I think that countries should be starting with that point, but it's probably got a long way to go.
Excellent. Thank you so much. I know we have kept you.
No, it's my fault. Thank you, Larry.
No, not at all. I've got a dozen questions, but they can wait. And I really appreciate your time. If there are any other questions from our attendees, if we can hold Justine for like a second more. Otherwise, thank you.
Thank you. And please email me if what I've said doesn't make sense. I'm happy to engage.
All right. Thank you very much.
Thank you.
All right. We're running, actually, this is very unusual in conference. We're running slightly early, so we will take the 5-minute break that was on our program for 5 minutes from now, and we'll give Lucas a little more time. We'll reconvene roughly around 10:25 or so, and then we will give the floor to Lucas if that's agreeable to Lucas. All right, so 5 minutes, and we will all be back. All right, folks, welcome back. And we will continue the presentation. It's my pleasure to introduce Lucas Roorda. But Lucas, you're going to introduce yourself and then proceed. So it's all yours.
Thank you very much, Larry, and thank you,
Right.
Larry and Claire.
And sorry for the informality. I've never been a formal kind of person, so so take it away.
No, thank you. No, me neither. So I'm very happy. This is slightly more informal than some conferences or workshops are, and I think seeing the participants in this conversation, I think this community is still so small that most people will know each other on a first name basis anyway. So it might be quite artificial to do it very formally. But yeah, thank you for setting up this workshop, and thank you for inviting me into this project with all these amazing contributors that I hope to also have a bit of a part in. And it's a bit strange that I'm relatively early in the program, given that my contribution really focuses on let's say the final bookend of the due diligence process, and that's the liability aspect. Of course, there's more presentations coming up that tackle aspects of remedies and liability. So also very interested to hear what's coming after me. But let me just also share my screen and give you a bit of an idea on what I will be doing. So my contribution was really focused on foreign direct liability cases, which basically means transnational litigation, civil litigation, which thus far, now I emphasize thus far, is mostly taking place in mostly European courts, US courts if you also count ATS litigation as foreign direct liability, which you could. But of course, it's not necessarily exclusive or will remain exclusive to EU courts. However, given the developments in terms of the EU Corporate Sustainability Due Diligence Directive, and of course the proposed binding instrument, I thought it would be interesting to look a bit at how do these mandatory due diligence laws, what could they potentially have an impact on foreign direct liability? So just very shortly to here we are. So just to define it for those who aren't really familiar with the term, I think most of you are, so I can do this shortly. We're talking transnational civil litigation, non-contractual litigation, directly suing for remedy. So I try to distinguish this also from any type of public actions, public interest litigation started by NGOs, although they tend to use the same sort of legal construction or are inspired by some of these cases. But I mostly focus on litigation directly for remedies. These cases usually utilize domestic civil law, usually either tort law or wrongful act law in civil law systems, and so are also within domestic civil procedure. The focus of my contribution, and I think also the focus of most of these cases thus far, has been on the United Kingdom, well, English courts specifically, and the EU, which thus far has mostly meant Dutch courts. There are cases in Germany, there's cases in France, cases in Sweden, but the main emphasis has been on English and Dutch courts. So most of the examples that I use in the study are also coming from English and Dutch courts. But again, this is not something which is or will remain exclusive there. It's just where it started. And some of the cases you might be familiar with, so the Vedanta case, the Okabi case, Fort, Nigerian farmers. So this is the pollution case in the Dutch courts. Actually, the first case that was successful on the merits. So I think it's also, again, good to keep in mind that these cases, there's a lot that's written about them, but we've just thus far only had one where the litigants have succeeded on the merits and also on appeal. So most of them dismissed or settled at an early stage. So there's also a lot that we don't know about these cases, and I'm not going to talk about it, but I think that's also important. I try to emphasize this in my contribution. A lot of what we think we know about these cases is based on what could be possible, and it's slightly speculative because, well, we just don't have a lot of final decisions on the merits. Now, how feasible these are is really dependent on the particular legal system where they are filed. So depending on specific procedural rules, because again, they're filed as domestic civil claims. So they can be different from system to system, even if you're within the EU with a large degree, although not exclusive, a large degree of harmonization between EU countries. And it's also good to keep in mind that these are usually last resort measures. So a lot of remedy questions are are just taking place at the level where the actual harms take place, and it can be in a non-judicial way. It can be through a corporate grievance mechanism, can be in national courts. These are really the exceptions that generally can't find remedy anywhere else, and then this is sort of your last resort because, as we'll see, they are expensive, they're complex, they take a lot of time, and there's certainly no guarantee of success. You could almost say there's a guarantee of non-success. So by the time claimants bring their cases in European courts, coming from foreign harms, you're really in this sort of exception of the exception situation. So I don't want to undermine my own contribution, but I think it is important that we don't see these as exemplary. Rather, they're, you could say, litmus tests of how well we're still able, for the most egregious of violations and the most egregious harms, to find some kind of remedy somewhere in some legal system. And what I've been doing in the contribution is look at these basically through the lens of barriers to remedy. If you're a litigant, what sort of barriers do you encounter? And this is, as Larry might talk about later, this is really sort of the UNGP framing through Principle 26, that there's no obligation to give these cases access to remedy or access to court, but states are still supposed to look at like what potential barriers to remedy are there for legitimate claims, and are they supposed, and what sort of, which of these barriers can be addressed? Like, are there like unreasonable difficulties that claimants run into when bringing their claims abroad? And what you see in these cases, there's a few that very much tie in with procedural questions of any extraterritorial non-contractual lawsuit. And the first is the question of, do courts actually have jurisdiction over either the parent company, the one that's actually in the state where the litigation is taking place, but also a foreign subsidiary or a foreign supplier, a foreign contract partner? Because usually these come from harms that are really a product of just national supply chains and the co-involvement of a company in a European state and a subsidiary or contractor abroad. And do courts have jurisdiction over both? Another question is really which law will be applied to the case. Just a standard conflict of law question, but are we going to use host state law to address these issues? Are we going to use the law of the forum to address these issues? Generally, it's the former, it's foreign law, but there have been cases where, for example, to avoid unreasonable time limits, there's been an appeal to foreign law to address the substance of the case. But depending on the law that you're going to use, it's also a question of, is there even a legal basis to sue any of the companies under? And this is like a sort of like the paradoxical situation where if you apply foreign law, then it's more easy to litigate against the subsidiary present in that foreign place, but there might not be any type of duties for any parent or lead company abroad. And the other way around, if you have laws that apply to the lead company setting policies and so on, it might not apply to the subsidiary abroad. And so in these cases, in a lot of them, you see sort of a combination between like broad negligence claims for the parent company and then more statutory basis for the subsidiary that's really domiciled in the place where the harm occurred, and so on and so forth. So, but finding one, and this is of course these three things are very much entangled. This can be really the source of a lot of protected procedural litigation. Even in the Dutch cases, you see cases taking 6-7 years, over a decade, before all these like procedural issues are settled and we can actually move on to the merits. And there's a lot of practical issues, access to documentation, evidence. Now, this might depend on your particular discovery rules of the forum. But this is really one of the crucial, if you talk to any lawyer in this field, this is or any attorney, this is really the crucial issue. Can we actually have access to a company's internal documentation. I mean, the problem in a lot of these cases is, did the parent company exercise sufficient oversight? What did they know? What could they have done? How much control do they have over their subsidiary or supplier? And to know that, you generally do also need to know a lot of sensitive internal company information, stuff that's not readily available. So you need to have some kind of disclosure proceeding to get access to those. And depending on where you litigate, in the UK, it's much easier than in the Netherlands, for example. You might or might not have access to it, whereas the defendant company does. So that sort of inequality is also very crucial to these cases. Of course, with all complex and lengthy cases, there's financial burdens. You have, of course, the costs of even bringing the case, representation costs, but also things like translators, experts, getting the litigants, the victims, to actually travel to the forum, which is, of course, if you're talking like transatlantic flights, that's an expensive thing to do. And this doesn't take place just over 1 or 2 hearings. If you're really unlucky, and this is a very procedurally tricky case, it might take, again, over a decade, and it's a decade of spending money, which, again, if you're litigating in, for example, the UK, you might have the opportunity to arrange some kind of contingency fee or no cure no pay arrangement. If you're litigating in the Netherlands or Germany or any other continental European state, often you don't. So again, depending on particular forum law, you might or might not have access to particular financial arrangements. There may or may not be an NGO that's supporting you with or without its own goals. And it's also difficult to find actual lawyers willing to take on these cases, especially if there is no good financial arrangement. Again, these are uncertain cases that might cost a lot of money, but not like bring a lot of money in. And you might have all the like willingness in the world, but if there's no feasible business model for a law firm, yeah, you're not going to really get into this type of cases. So what you also see is that most of the cases were litigated by exactly the same lawyers because they specialize and have found some way to make it work, but a lot will not even try. So this is a problem often cited in host state litigation, but it's just the same in this foreign liability, in these foreign cases. And there's a lot of extra practical issues that you might run into. One that I've highlighted in my previous work is also just the passage of time. So these are cases filed by natural plaintiffs or natural claimants against a legal person, and the legal person can switch CEOs, personnel, lawyers over the period of that decade or even 2 decades, whereas the claimants are principally the same people and sort of have to continue this and bear like the burdens and just the physical burdens of litigating constantly abroad, traveling. And like time works against you if you're in this kind of litigation. So, and there's of course more a lot of more potential barriers that we can talk about, but these are the ones that I pulled from the history of case law here. So then the crucial question is, what would human rights due diligence, and especially mandatory human rights due diligence, do for these cases? And this is coming from the starting point is that, of course, HRDD is meant as like a preventative or mitigating measure and not necessarily specifically a remedy mechanism. But as we can see in both the proposed binding instrument and the European CSDD, is that there's this contemplation of liability throughout the entire instrument. So there's this explicit idea that this should also be a potential ground for liability. If you don't do your due diligence and damage occurs, you should be liable. So what happens is basically MHRDD or HRDD takes the place of the standard of care you ordinarily use as in your negligence claim. And other laws like the French due diligence law do the same thing. Even the German law, and I might be corrected on this later, could potentially, it doesn't explicitly say so, but could potentially be invoked as a potential standard of care. Like it doesn't necessarily prohibit it. But then the question is, how does that help you? If you have this additional basis of claim that you can use, does that actually lower your barriers? Because I didn't really discuss the substance of using this as a standard of care. I really try to examine what does it do with the barriers to remedy. And what you see is that here the divergence starts. So whereas in the proposed binding instrument, there's also these proposals to directly address these, especially practical barriers, so financial barriers, access to evidence, and so on. You don't really find those in the CSDDD. So it does explicitly say that you should be able to litigate and should be able to sue based on the standards in the directive, but it doesn't really address any of the barriers you might encounter once you do so. That sort of leaves it up to the member states to solve that problem. What it does do, this is the CSDDD, is designate itself as, between brackets, overriding mandatory policy of the forum state, which basically means that for applicable law purposes, if you're suing, you can use this instead of foreign law that might otherwise be applicable. I don't have time to really go into like in depth on conflict laws rules here, but suffice to say that if you want to sue based on the CSDDD, you can skip basically ordinary conflict of law rules and directly use the norms of the directive. Now, that does solve your problem of applicable law or whether or not there's actually a standard to apply to the corporate behavior. It also, you could say, indirectly impacts financial and practical barriers because, well, if there's no lengthy procedural litigation on jurisdiction applicable law, because again, think of the if you're suing a company domiciled in the EU and you have this mandatory use of the directive, well, then there's also automatically jurisdiction under the Brussels I regulation. So that saves you a lot of procedural hustle before you can actually get to the merits. And that, of course, lowers indirectly your financial burdens and also like saves you from having to prove that there's actually this connection between the parent and the subsidiary company because, well, one, the directive says that the parent has to exercise this oversight, and two, we can litigate against the parent company anyway. We don't have to talk about any type of control or duty of care from ordinary negligence. This is within the EU. However, it doesn't provide any other practical procedural aid. So there's no contemplation of legal funding. There's nothing in terms of like presumptions, reversal burden of proof, anything that would make it like practically easier to put your case before court. There's nothing in terms of access to company documents for litigation purposes, but also nothing like disclosure to victims in language in terms that they can understand, any type of facilitation for people to actually travel to the EU and litigate based on this law. So what I say in the contribution is it looks more like a civil enforcement mechanism rather than a remedy mechanism. It's really much more conducive to actors already present in the EU and familiar with the EU system. So think NGOs or any type of representative of somebody abroad than it really is for rights holders and victims. And also, there's in contrast with the sort of open norms that rights holders can use, there's very detailed defenses for corporations. So, for example, if the harm only arose out of outside of an established business relationship, there's no possibility for liability. Within that established business relationship, the company is only directly linked to the harm, but they had contractual assurances that that it wouldn't happen again. That can actually be sufficiently a defense against a liability claim. And those are quite detailed sort of procedural aids for companies that you don't see on the part of victims or rights holders. So that I think already that sort of increases the already existing inequality between those two parties. And let me just end by saying a few things about my issues with the CSDDD, because I do share Justine's overall view that having something is better than nothing. But I think there's if you compare the PBI, which does have all these procedural aids, but in my view is quite a long way from actually being established, and then the CSDDD, which is much closer to actually being enforceable law. There's a few things that I think could be improved. So it does help, I think, to have specific standards of conduct in being like HRDD obligations compared to these much more open-ended negligence or like do social care norms that we know in the Netherlands or any comparable doctrine that you might find in most legal systems. Like this is much more specific, but it needs to be more detailed than it is now. And I think the sectoral agreements and the sectoral specification might help, because otherwise what you'll have is a situation where victims first have to argue that this was actually the standard of conduct, and you have like endless litigation over what this directive or its implementation legislation actually means. And the same goes, for example, for disclosure obligations towards enforcement authorities. How much a company needs to disclose really matters for the question how much victims actually can be helped with that information, how much they can actually use that for litigation on particular harms and particular violations. So I do foresee the initial wave of litigation to be likely much more burdensome than the existing models for foreign direct liability. So we have quite a lot of case law now on issues of control, issues of duty of care. UK Supreme Court has been quite explicit about what you can use to argue that a duty of care might arise. They've been very detailed in the Vedanta and Akpabi cases. And now we have this new legislation that says, yeah, we're going to basically reinvent the wheel and you have to try it all over again. So I do anticipate the first cases to be much less successful than I think people might hope. And if you look at the first cases coming out of the French law, that is exactly what is now happening. Courts just not seeing sufficient specificity and obligations to come to a finding of liability. This is going right. It also strikes me there's a contrast with existing European laws and proposed European laws, for example, on liability for AI in all types of products. The sort of AI package that the European Commission has proposed, where there are all these procedural aids, types of consumer protection when they litigate, evidentiary presumptions, all kinds of stuff that helps the weaker party litigate against a much more knowledgeable defendant. You don't see that in the CSDDD, and I think it really needs to be in there. And I know the European Parliament has fielded some amendments that might help rectify this a bit, but thus far it's mostly missing. And what also really strikes me is that the EU, like it has done on a couple of other issues, is it tries to sort of position itself as like a normative epicenter of this problem. Like we are now the ones creating the standards, and in absence of the PBI, which the EU, by the way, of course, is not negotiating in, basically trying to set the standards that, given the scope of the directive, a lot of companies operating worldwide will have to follow, but without introducing the proper checks. And I'm slightly more pessimistic about the involvement of stakeholders than Justine is, but at least from a liability perspective, the EU is not willing to relinquish control over interpretation of that standards to actual rights holders through litigation. Now, of course, there's a lot of amendments that are pending, and there might be a lot of implementation questions in the member states that might resolve some of these issues. But I think the overall problem of the direction that the CSDDD is taking, compared to, for example, the PBI and what other states have been asking the EU to do, like basically also give the practical possibility to litigate, to make it actually feasible to come into EU courts. It's very clear that that's the direction the EU does not want to take. And I think that's quite concerning moving forward, where liability is really, you could say, an insider game rather than an actual legal check on the operations of corporations, on whether or not their preventative mitigation measures were sufficient. And I didn't really address it explicitly in the contribution, but if you also see the relative lack of enforcement standards and investment in enforcement agency, I'm really worried about how much control this gives to corporations in determining their own standards, and how little checks on that control this creates. So I'll leave it there. This is more like a technical issue I can talk about later, but I'm very much looking forward to your questions. And again, thanks for the attention.
Thank you, Lucas. Any questions from anyone? while people are thinking, we've got about 5 minutes or so. While people are thinking, I will abuse again my position and ask you a question. From an American standpoint, certainly one of the more interesting things about mandatory human rights due diligence is the amount of information and data that it produces. And in the context of remedial actions like this, I'm wondering to what extent have courts been willing, especially outside the US, to reach in and permit the discovery and the use of that information in the remedial litigation. That is, and it had worried some companies for a while that, in fact, if they went ahead and did all of this, that they would expose themselves much more and certainly weaken their ability to defend their positions if everything they've done in the context of mitigating, preventing, and the like would then be discoverable in a remedial action. And I don't know whether the cases suggest a proclivity to do that or whether that remains sort of protected.
Yeah, good question. I think there's a couple of elements to that answer. The first is that I'm not aware of any cases where litigants have actually invoked or tried to use information disclosed via any type of like transparency or HRDD mechanism yet. Those might come, but one of the reasons I think for that is that the requirements are thus far so vague that it really doesn't help you at all anyway. Like the information that needs to be disclosed is very general, and the criteria for disclosure currently, that's one of my big critiques also of the CSDDD. There just aren't a lot of criteria and a lot of standards for what actually needs to be disclosed. I'd say if you're any lawyer worth their salt is already able to find a lot of much more detailed information about a company's operations related to a case outside of what these transparency and HRDD mechanisms will give you. Now, the second element is like, would this more general information help you, for example, in the discovery procedure? Now that question is, I think, only relevant really for states that do have like a more meaty disclosure or discovery rule. Also, if you're in the Netherlands, not so much, because you already pretty much need to know which exact document you want to have before you can even request a court to force disclosure. But let's take the US and the UK, for example. I haven't seen it yet, but I do think there's an increasing willingness to do so. And I base this mostly on, for example, the UK Supreme Court saying in Vedanta, one of the ways to argue the possible existence of duty of care and just basically sort of pass that first test of do you have an arguable claim and move on to disclosure is a company holding itself out to other stakeholders as having control. So, and what is a due diligence statement or any type of disclosure of this type of information other than holding yourself out to have this control and so on? But that didn't come from the due diligence laws themselves. That came from the UK Supreme Court saying, hey, look, this is the sort of stuff that you get, it's not free to tell your shareholders and any other stakeholders that you are in full control of your supply chain. If this is what you're holding yourself out to be, anyone trying to litigate can also use that to sort of argue, to basically make you show how you use that control. And I don't think the existence of these paradigms really changes it that much. I've also seen courts being a bit more willing, Dutch courts as well, to look at what companies have already been doing and saying. So, for example, in the 4 Nigerian farmers case, the Dutch courts going, look, Shell, you've said multiple times you respect the UNGPs and you have this control. So don't tell me it's unforeseeable that you might be sued on that basis. So the willingness of courts is there, but how much of a risk it is to companies, I don't think it's that much.
Beautiful. We've got 3 questions, one from Anna Prada on Q&A, and then Birgit and Claire. So if we can do that and then wrap up this session. Anna's question is, I've always thought that alternative dispute resolution mechanisms are a good option. In fact, the UNGPs mention them. Do you think this could be a solution? Do the legislation in HRDD address these mechanisms?
this wasn't really the focus of my contribution. So really focused on judicial remedies and transnational litigation. But of course, the answer is yes, of course, that needs to that can be a part. But I think tying it into my contribution, my main question for any type of non-judicial alternative dispute resolution is how does it, first of all, is it backed by any type of judicial remedy? I mean, that's also pretty important. If you don't have access to court, you're always sort of on slightly shaky ground if it doesn't work out with whatever other mechanism you use. And two, do courts even take account of the previous steps, any type of alternative dispute resolution mechanism, whether it's a corporate grievance mechanism or whether it's an ombudsman or an NCP or a mediation procedure? Do these really feed into each other? Like, are we having an actual remedy ecosystem, or are we having some separate non-communicating vessels? And I think the main body of my contribution was really try to sort of point out all these enforcement and remedy mechanisms are communicating vessels, and if we like don't see that sufficiently, then they're all going to be less effective than they're supposed to be. So hopefully that answers a bit.
Birgit, and then Claire, and then we'll wrap it up.
Thanks, Lucas. I wonder, what you would evaluate to be the prospects of judicial reading down, basically, of the scope for liability, as presented on the face of mandatory due diligence statutes, with reference to fundamental legal values and principles such as legal certainty, the interests of justice, in the context of tort, of course, other elements of the mechanics of tort, and how, at least in a common law system, tort liability is discerned with reference to foreseeability and so forth. Of course, where there's liability foreseen, which might intrude also on elements of contract law, privity, and so on. What do you think, of course, in the set of cases you're looking at where it's foreign liability, we also have, principles, perhaps vague and hard to predict exactly in the scope of their application, but comity, and, sort of the interests of the state in that regard. So what do you think, is it possible to make any general remarks about how these, sometimes more nebulous, but fundamental principles might be, thought by judiciary to intrude into the interpretation of, these new forms of liability based on mandatory due diligence law? So that's my first question. The second question that I have, I guess is linked to that is, about the legalization of the due diligence concept and the attachment of tort-based liability to legalized due diligence. Is that, what are your general reflections on the sort of novelty, the appropriateness, the innovation that this embodies? And then my last point is about the example you raised concerning the EU AI legislation. So in that context, you flagged, I think very usefully, that there are additional protections provided to rebalance, if you like, or to counter power asymmetry between the duty bearers and the rights holders in that context. Is that something which it's only possible to do meaningfully on a sectoral basis, or a technology specific or a sort of context specific piece of legislation? Is that the reason why we see those provisions and those measures incorporated in EU AI legislation, but we don't see them in the general horizontal due diligence legislation? Because that goes, I think, back to the discussion we had at the beginning with Justine about sector-specific approaches. Maybe we can only, hope to introduce these compensatory measures in a more context-specific piece of law, then we can, you know, in this horizontal legislation which spans so very many different jurisdictions, industrial settings, production relations, and so on.
Lucas, if you can keep it really short, I don't want to cut into Birgit's time.
No, neither would I, because I'm also very interested in her contribution. So yeah, I'll do my best. So reading down the standards, the simple answers, it really would depend, I think, on the particular state or particular member state. And I think you can see in English and Dutch courts, they've been increasingly willing to actually sort of like stand a bit more against the companies and take a more, so you'd say, pro access to justice stand than previously. And just on a matter of sort of, you could say, judicial integrity, I think it's unlikely that courts would then step back again and sort of read down the new standards. I think they would try and keep sort of the previous case law and keep those sort of, not just like the exact standards, because those can't be applied like copy paste, but just the attitude towards this type of litigation, and as a counterbalance to corporate power, which they increasingly are doing, like maintain that sort of attitude. However, I have no idea how that works for states that don't already have this sort of body of case law that courts can build on. And I think this is also it's a human thing where courts don't want to be the first one to take a radical step. You're always trying to be in line with previous case law and previous jurisprudence, and not be the one that sort of jumps ahead of the pack and then gets all the critique. And that makes it easier for, I think, English and Dutch courts to move along with this, because there's backing from the Supreme Court, because there's backing from courts of appeal, because there's literal previous case law they can build on and sort of try to integrate these new standards and uphold sort of the existing ideas of access to justice and so on. But you see French courts already being very reluctant to take that step because the law just isn't clear enough. And I think regulators can help courts in that respect by being much more specific in terms of standards, and not like putting it to them to take the risks. I think that would be the shortest answer I can give. The judicialization of human rights due diligence, yeah, I know. Yep. Yeah, that's I don't have much to say about that. I think I agree with that concern. This is a standard that was developed as a way for companies to operate, and now we're trying to flip it on its head and use it as a sort of standard of care in litigation, which it was never designed to do. It's literally derived from a mechanism between companies and their shareholders, to understand the way to operate, to understand business, and completely judicializing it in a sort of retroactive way. I think that's the main source. I think the problems that I've sort of addressed, and I think just I would say I've preferred the directive. Just leave it alone. Just don't talk. Don't say it explicitly. Just this is the standard, and then see how much that, and then let courts or member states work that into existing ideas of open duties of care, open standards, which we already do. And then finally, the AI directive to comparison. I don't think the AI package is very sectoral either. It's extremely broad. It's about AI in all kinds of technology sectors, and even though it's limited by saying it's an AI question, I think you really should look at this package through the lens of consumer protection in a broad sense against a technology that they don't quite understand. You can apply exactly the same reasoning to whatever other type of technology. It is not really sectorally defined and applied in those standards either. So I don't think it's necessary, but, and I'll stop, I do think it's more effective and more helpful if you develop those presumptions and standards then in a sectoral way. So having an overall presumption that says, look, if you can establish that there's like a prima facie violation of the due diligence obligation, and then the company has to show that that didn't cause harm, okay, that would help, and I think it's very possible. But what that means per sector, of course, I think you can't do that in one overall directive. So yeah, yes and no. I don't think they do it in the AI thing either, but it would be better than just the overall presumption.
All right, well, thank you, Lucas. The good news is that this is just an absolutely brilliant additional contribution to an already brilliant set of comments. The bad news is that we're not going to have a break because we're running late, and so I would like to now. Oh no, no problem. I mean, I wish we could go on, but I'd like to give the floor to Birgit. Birgit, if you can introduce yourself, and then the floor is yours.
Thank you very much, Larry. I do not have such a nice PowerPoint presentation. I sent you only last night 3 slides, which I would like to, as you are the host, you probably can actually put them on the screen. But
well, as you speak, I will find them and
okay.
and put them up. So.
It's only 3 slides, which just actually support what I'm saying. By way of introduction, I have 2 hats on. Yeah, this is already close to a hat. But not mine. On one side, I'm professor at Bremen University for international law and business ethics, and with the other hat, I am Europe Sustainability and Governance, Chief Sustainability and Governance Council for Dentons Europe for a law firm. And in this capacity, I have to implement actually the national laws, the German law, but also deal with all kinds of client requests. And so what I would like to share with you, and this is actually the slides which I've also brought with me.
They're on their way.
Actually,
they're on their way.
They're on their way. Super. So is really the practical side of things, because in theory, a lot of things sound marvelous and straight and clear and fair. But when you look at the day-to-day practice, dealing with human rights due diligence, with codes of conduct, the story is quite different. And I would like to introduce also this kind of practical challenges we are facing on a day-to-day basis as a law firm and in our capacity as supplier of services to a couple of thousand actually European clients. Let me just give you a brief introduction to my part, which is actually the supply chain due diligence law in Germany. In 2021, the Act on Corporate Due Diligence Obligations in Supply Chain was published in the German Federal Gazette and has come into force on January 1, 2023. So very recent. Roma locuta, causa finita? No, not at all. The German Supply Chain Act is only a further milestone in the regulatory program laid down by the UN Guiding Principles, the OECD guidelines, and the National Action Plan on Business and Human Rights, international and national soft law, and paves the way for corresponding EU supply chain legislation and Europe-wide implementation. The German Supply Chain Act establishes the responsibility of companies for the implementation of human rights and environmental due diligence in their own organization, in their group of companies, and in their supply chains as their own duty of care. And the key elements of this duty of care are laid down in Section 3 following of the Supply Chain Act. This due diligence conception by the Supply Chain Act raises many questions, both in principle and in detail. One of the key issues is whether the due diligence obligations are merely procedural obligations, in particular whether they require only to undertake best efforts, or whether at least some of the provisions contain a duty to achieve results. As far as I can see at the moment, the European Supply Chain Directive draft takes up basic conceptual features of the German Supply Chain Act, but has significant deviations, which actually will lead to adjustments and potentially a revision of the Act. When the supply chain, or already when in the preparation of the Supply Chain Act, the question is, what kind of law is that? The way the German Supply Chain Act is actually established is a hybrid that cannot be clearly assigned to any area of law, in that it establishes protected legal positions with direct reference to conventions under international law, the violation of which is to be prevented, mitigated, or compensated for based on a risk management system that is prescribed in detail. The enforcement mechanism and sanctions include, however, administrative measures, including actually the establishment of a new agency dealing with the enforcement of the Supply Chain Act requirements, criminal fines, civil liability only to an extent it is established outside of the Supply Chain Act. So this type of civil liability is maintained, but there is no separate and new civil liability clause in the Supply Chain Act. And also as another sanction, the exclusion of public procurement procedures. So quite a mixture actually of imposition and enforcement measures. Since public, criminal, and civil law approaches and elements are combined in a hitherto unprecedented form, there is already talk of a new legal field of supply chain law. I will simply actually mention a couple of things. The scope of application at the moment is fairly straightforward. At the moment, the Supply Chain Act directly applies to companies with more than 3,000 employees in Germany. As of January 1, 2024, the threshold will be 1,000 employees. But the problem is not so much that the Supply Chain Act applies to these companies directly. The bigger problem is, which has been underestimated in our opinion, is that it indirectly covers all companies in the supply and service chains of directly obligated companies. And this includes actually all kinds of law firms like us. The due diligence, they have points of reference. There is the explanation, what is a supply chain, what is a legal position, risk and violation. So this is roughly described more than defined. I would like, and also the question, what is a violation? I would like to go straight, as we have only limited time, to one of the central questions, and this is, what is this due diligence conception? And there is actually a really hot debate, only partly informed actually by academic research and discussion with regard to the UN Guiding Principles. So there is a wild discussion going on in that regard. Section 3.1 of the Supply Chain Act requires or stipulates that companies are obliged to observe human rights and environmental due diligence obligations in their supply chains in an appropriate manner, with the aim of preventing or minimizing risks to or ending the violation of human rights or environmental obligations. The broad responsibility rationale is specified in two ways. One is elaborating the elements of due diligence in the law, and two, by proportionality criteria, which are intended to provide guidance for the appropriateness of the duty of care itself or its implementation. Even that is not entirely clear and disputed. Just briefly, a look at the elements of the due diligence. Following the UN Guiding Principles, at least in principle, the duty of care includes, and these stipulations are actually comprehensive. It's not a general clause where you may add additional elements of due diligence. This is it, this catalog. One, the establishment of a risk management system. Two, the appointment of a human rights representative. Three, a regular risk analysis. Four, the issuance of a policy statement. Five, the establishment of preventive measures in the company's own business area and vis-a-vis direct suppliers. Six, the taking of corrective actions. Seven, or remediation actions. Seven, the establishment of a complaints procedure. Eight, the implementation of due diligence with regard to risks at indirect suppliers. This is one of the main features. Actually, the due diligence system applies to the company's own business, plus all the direct suppliers. With regard to the indirect suppliers, only when there is really a risk or the company has reason to believe that there are problems with an indirect supplier. The other question again arises, what are the criteria for that? 9, this is important, documentation, the kind of regular monitoring of the company internally, and reporting both to the general public and to the agency, which will check the report and come back to the company in case they find any reason to question or actually that they do not fulfill their requirements. With regard to the proportionality criteria, Section 3.2 stipulates the appropriateness of behavior that satisfies the due diligence requirements. And this is determined by 1, the nature and scope of the company's business activities, 2, the company's ability to influence the direct perpetrator of human rights or environmental risk or violation of a corresponding duty, 3, the typically expected severity of the violation, its reversibility and likelihood of the violation of a human rights or environmental related duty, and 4th, finally, the nature of the company's contribution to the human rights or environmental related risk or violation. So the question was, what kind of how do we qualify this due diligence? Because it is actually foreign to the German laws otherwise. So there is quite a hot academic debate on actually how we deal with that from a dogmatic point of view. What is it really? Is this only actually a procedural requirement? Is this a requirement to actually a duty to have make best efforts and that's it? Or do we have really kind of a staggered duty to achieve results? At the moment, a lot of actually academic contributors are jumping on the explanatory memorandum because a memorandum says very actually in a very kind of simple way that it is an obligation to best efforts. Although this interpretation would be desirable from a point of view of the companies, in particular where it's difficult to ensure success for factual cultural reasons, I think the question is whether this interpretation is too simple and really correct. The explanatory memorandum says in that regard, the due diligence obligation under Section 3.1 regulate due diligence, i.e. a procedural obligation. Companies are not required to guarantee success, but to implement the specific measures listed in 3.1. This means companies must carry out the measures listed within the limits of what is feasible and appropriate in a given situation, but not, for example, to prevent all human rights risks. The explicit naming of the objective expresses this. The extent to which the measures must be implemented is not rigid, but is to be assessed depending on various factors listed in Section 3.2, the proportionality factors. One thing is clear, says the explanatory memorandum. No company may be required to do anything that is legally or factually impossible. The company has fulfilled its due diligence obligations, even if it could not trace the entire supply chain or take certain preventive or remedial measures, because this would have been impossible in fact or in law. Legally impossible means, for example, that it would violate applicable law, with a behavior. Factually impossible means, for example, that a company has reached its limits due to a lack of influence. So the question is, and this is my personal opinion, I think this explanatory memorandum is too simple and does not reflect actually the wording of the law, and an explanatory memorandum cannot do away with actually a quite explicit and unambiguous wording of the law. And the law says actually an effort is not enough. You must fulfill actually the due diligence obligations. You must actually establish a risk assessment system. This is a must. There is, and you must fulfill that. And there is even also in certain requirements, like in Section 6 and also Section 7, it is fairly clear. It's not even sufficient that you establish these kind of measures, but that you have to achieve a result. And for example, just to pick one, the wording of section 7.1, which is dealing with remedial measures, says if a company identifies a violation in its own business area in Germany, it must take appropriate remedial measures to prevent or end the violation or minimize its extent. Domestically in Germany, the remedial action must always result in an end to the infringement. Abroad, the remedial action must usually result in an end to the infringement. The issue here is not an effort, but the mandatory cessation of the violation, which is actually clearly a defined success. In addition, the competent authority must not only detect violations of the due diligence obligations, but must also eliminate and prevent them. And also in section 10, we have kind of a staggered actually clause, because section 10.1 says you have to actually apply continuous monitoring of what you are doing in the implementation of the due diligence requirements. You have to report on that regularly, both to the agency and the general public. And the agency can actually go enter your database and ask actually for all kinds of information they want to have. And with regard to the reporting, you do not only have to identify your negative impacts and what you are doing against that, but also you have to evaluate to what extent these measures were effective with regard to actually achieving the goals of preventing, mitigating, and remediating. And if you realize that what you're doing is not sufficient, you have to do better and optimize your measures. So this is actually clearly a goal-oriented actually purpose and measure, which is not adequately characterized when you call it actually a best efforts requirement. Let me come now, and we have one slide already on the screen, the first slide, thank you, to the challenges, dilemmas, and the criticism. You see here actually kind of a simple slide where who wants to regulate the enterprise. Besides the state, the German Supply Chain Act and the European Union, we have directly applicable soft law, UN Guiding Principles, OECD, NGOs coming with GRI and other requirements, investors and financiers actually regulating through their loan agreements and through their investment requirements. We have rating agencies regulating through scores, which actually are relevant for any kind of then loans, etc. We have private standards like ISO, and we have export agencies which come up with their own standards in order to really applicable to the company in order to get export credits or any kind of support in that regard. So we have lots of different regulators trying to really influence the enterprise and steering it towards sustainability. All wonderful. The only problem, the standards are not identical. And this creates in the practice a huge headache. If we can go on to the next slide, please. The challenges are that one of the main challenges in the practical implementation of the Supply Chain Act in competition with soft law and other national laws in the supply chain. The German Supply Chain Act focuses on the companies falling in the scope of direct application. The challenges for companies in the supply chains are not sufficiently taken into consideration. We have raised that issue a number of times, both with the German legislator as well as with the European legislator. No way to really actually make them focus and see what's really happening in the supply chain and what kind of burden is established there. The situation can be illustrated by the challenge, and this is my day-to-day work, a challenge to a law firm, and the challenges we are facing as service providers in the supply chains of thousands of companies whose ESG policies and codes of conduct are informed by international soft law, such as the UN Guiding Principles and various and differing national hard laws. But all these standards are similar, but not the same. Lawyers as service providers, just to take us actually as an example, are members of clients' supply chains, which by law, we have listed a couple of laws here, or self-imposed obligation when they follow UN guiding principles or other international soft law and create their supplier codes of conduct. And they require also their lawyers to commit to compliance with ESG standards, often actually in supplier codes of conduct, contractual clauses, or questionnaires. In some cases, lawyers are also required to submit their ESG policies and proof of implementation and compliance. And the real result of the evaluation decides on the admission to panels and mandates. And if you are rejected for whatever reason, there is no legal remedy. You cannot argue with a client that he did something wrong in the evaluation or he took the wrong standard. You are simply excluded. Frequently, information is requested that is subject to attorney-client confidentiality or obligations that lawyers cannot fulfill, such as that you should not have any connection with business partners, including other clients, that possibly have a negative impact on human rights, even if these negative impacts are legal, according to applicable law. This also applies to audits to seek to comprehensively examine the firm's business operations and books, and thus access confidential client-related documents. Since the respective national legal supply chain requirements are not uniform, and the soft law otherwise used as a basis, such as the UNGP, allows for a wide scope for interpretation and implementation, the requirements vary significantly. In addition, we face actually the things are coming from both ends. We are squeezed in the middle, and we'll see that in a second with the other slide, because our suppliers, when we buy, for example, IT or paper or whatever, they also come up with similar demands on law firms as customers based on the Supply Chain Act, other national laws, or soft law commitments. Part of these demands from business partners usually that the law firm establishes and verifiably implements a supply chain management with regard to its own supply chains. But this leads to an increasing and burdensome compliance bureaucracy because the request is in most cases that neither the clients nor the suppliers accept that, for example, Denton's has quite explicit actually ESG related actually codes of ethics, etc. So we do have our own policy, but in order to prove to the outside world that they are compliant, they push down their similar but not the same codes of conduct on us, which ends actually, which leads us with actually a situation that we have to review on a daily basis, actually contract clauses, codes of conduct, questionnaires coming from actually all kinds of business partners, both upstream and downstream, all trying to actually impose their codes of conduct on us and trying to force us to push down and upstream and downstream their codes of conduct and pass them on actually to all our clients and suppliers. This is mission impossible to really make that clear. We simply cannot do that. So what we try to do is on an individual daily basis, negotiate each and every request in that regard. And what we expect that this will become even more burdensome. At the moment, we are dealing in particular with French and German clients. But when we have the EU Corporate Supply Chain Directive, Sustainability Due Diligence Directive, then we are talking about 27 different implementing laws with thousands of direct addressees and even more thousands of indirect addressees, all coming up actually as our clients or suppliers, trying to really push down their codes of conduct and their understanding what actually the requested laws require on us. So this is actually mission impossible. What we are discussing right now is actually to what extent we can engage develop artificial intelligence to assist us with this kind of wave we expect to really swamp over us. Another dilemma is actually and a major dilemma I see with clients is the enforcement of human rights standards, in particular in China. Larry, you are an expert on that. I do not have to go into detail, but the bottom line is, to make a long story short, that we see, as you may know, I'm also serving on the Human Rights Advisory Council of BASF. They have major operations in China. And the question is then, can we, even when the German legislator says we do not ask anything which is factually or legally impossible, nonetheless, you've seen that NGOs are actually questioning what BASF is doing in China, and they give a damn on what the German legislator says in its explanatory memorandum. They are still actually accused and approached to really stop their operations, to move out of Xinjiang. And then they are squeezed then also between the new anti-sanction laws in China, etc., which actually putting them on a blacklist in case they are implementing the German Supply Chain Act in China. So the question is, so what's that? I think we are caught in Germany. The German legislator said, oh, we do not ask you for anything which is impossible, but NGOs don't care about that. They ask for that. And so the legal criticism which we see, and I'm going to finish with that, is really that we expect that the German Supply Chain Act will end up in court, in particular also in the German Federal Constitutional Court, because a lot of its provisions are so vague that they are probably not satisfying German constitutional standards. We can probably come back to that later. But this is what we expect to happen, what the conclusion is, that the German Supply Chain Act promised to really create legal certainty, but what it created is a whole mess, actually, in particular in practice, where we actually are agree in principle that the companies should not lean back and actually not care about what's happening in their supply chain. But the question is whether a German national law does the trick and really will save the world. So I'll hand over to you, Larry, with that conclusion.
Well, thank you very much. It was absolutely brilliant, and you answered the question I was going to ask you about China. So thank you for bringing that in. We're running just a little late, and maybe we can take one brief question before we send it over to Carola. Again, no break, but all in a good cause. So if anyone has a quick question that maybe that you'd like to ask before we move on. The subject was, by the way, Birgit, just so extraordinarily rich. And I'll give them a second. But if they don't, I do have one. You touched on this very briefly, but you perked my ears up considerably. And that is, if in fact what we're seeing is a regulatory environment that is going to begin looking more and more German globally, you suggest quite rightly that it is beyond the physical ability of any large institution relying only on humans to actually comply, which means that human rights due diligence and human rights compliance is going to necessarily be digitalized, automated, modeled, and operated by and through AI systems, generative AI systems. And then the question would be, to what extent would this either impact or clash with or be aligned with the enormous efforts now within the European Union to regulate, manage, and operationalize AI and AI systems in human rights? So that's my quick question. I know Claire's got one, and maybe she can ask hers as well. And if you can take a very quick shot at an answer, we can move on to Carola.
Just briefly, I'd be very interested to know what would be the approximate formulation of a constitutional challenge of the kind that you said is possibly foreseen.
Yeah.
With reference to which, elements of the Constitution or rights in question,
Larry first. I think we have already now clashes with the European data protection regulation. And already now, because actually the protection, when you deal with human rights, you're dealing with personal information. and we need to anonymize, for example, any kind of information on specific diversity issues, etc., in order not to clash with the European data protection regulation. We haven't checked that yet. To what extent we have another clash with the AI regulation, which is up and running. So we did not check that. We are in this discussion. We are starting the discussion with our innovation team in order to see to what extent there are actually tools already out there which could assist us, and to what extent we can train these tools and amend them in order to really make them more supportive for us. But there are clashes in that regard. And the short answer is I did not check AI regulation yet, but this is coming up. Claire, your question. What we expect to happen is the German constitution requires two things. One thing is that the German regulator, the German parliament, has to actually take all the important decision itself and cannot actually delegate that to the administration. So as a lot of the clauses are very vague, we assume that actually the German legislator has not done his job properly, but has delegated actually important specification requirements concerning, for example, the legal positions, which shall be directly derived from certain conventions attached in an annex by actually the agency and by the enterprise, by the way, that without actually specifying that in more detail, as the legislator does when implementing conventions into national laws, we assume that this would be probably one issue where the legislator has not done its job sufficiently. The second requirement, constitutional requirement, is that that laws have to be defined and they have to be certain and clear and transparent, and that you can foresee what you have to do and what you cannot do. And there are certain clauses in the law, it's going too far now, but there are certain clauses in the law which are so vague that you can have very different interpretations, where we think actually the legislator has not told the companies clearly what exactly they may and may not do. So these are the two constitutional actually requirements. Basically, these two ones, there are more, but this is basically, it's a matter of certainty and also the so-called essential requirement clause that the legislator has to take all the essential decisions and for democratic legitimacy reasons.
Well, thank you very, very much. We are running a little late, and I want to give Carola a chance to elaborate her presentation. So without further ado, Carola, it's all yours. Carola, you're muted.
Sorry for that. So thank you very much, Larry. I hope you can hear me now clearly. So I am from the University of Copenhagen, and I give a paper on, can you see it?
Yes, we can see it.
Yes, the problem is I can see it, just a second. Okay. So I will focus on the relationship between human rights due diligence and tort law. So I basically focus on tort law instead of the whole range of civil law. I really hope that there's not too much overlap with Luca's paper, but from what I have already heard, I don't think so. So he focuses more on the procedural barriers in that regard, whereas I have a strongly doctrinal and principle-based focus on substantive law, and basically try and also have a more optimistic outlook as I try to really pave a doctrinal way on that relationship. So yeah, we all know basically this overriding idea of the UN guiding principles, yeah, to change the fact that each legally distinct entity is subject to the laws of the countries in which it operates, but the corporate group as a whole is not governed directly by international law, which can easily be transposed to tort law. Basically, yeah, the challenge that tort law follows the company law principle of limited liability, yeah, and to get to a corporate-wide or supply chain-wide liability. The paper basically has a three-step argument. So first, it focuses on doctrinal issues of tort law in transnational supply chains, with basically the two subcategories, yeah, of the duty of care beyond the immediate legal person and the standard of care. It then looks at how the UN guiding principles change that picture. What is their impacts? Again, in two steps. First, analyzing the parallels between tort law doctrine and the UN guiding principles, and then looks at the impact and potential impact. And then the third step is basically the impact of the concrete binding national due diligence laws, which take different approaches towards the issue of liability, basically either remaining silent on the issue of liability, ruling it out, like the German law does, or including an explicit liability clause like the French law or the proposal for the European Sustainability Due Diligence Directive. So basically, yeah, first, yeah, I look more closely on the doctrinal relationship between tort law, societal norms, societal expectations, and practice, yeah. So supply chain-wide due diligence taken in practice, self-commitments, risk management systems, and so on. And so basically this development of standards, yeah, its impact upon tort law. Then add the UN guiding principles to the picture, yeah, strengthening that relationship. And then as a third step, basically also the binding supply chain due diligence laws. So in principle, yeah, what we have, what is the challenge? Yeah, we have to create liability for legally independent legal entities. In a situation, yeah, in a practical situation where we in fact have a complex allocation of responsibilities, resources, and control. And of course, there are tort law principles which back such a duty of care, which is the generation or co-generation or maintenance of a risk, the control of risk or the potential to do so, an assumption of responsibility, yeah, at least for certain management duties, which then leads to the required proximity, yeah, between the company and the victims, and the victim's dependence on the care of that company. So basically, yeah, we have, yeah, also with a view to already carried out due diligence practices, best practices, standards in practice. So we have different situations, yeah, in which tort liability could be imposed on the parent or the leading company. Yeah, the first situation is the parent company really has played an active role, yeah, giving orders or instructions to the subsidiary or supplier, or yeah, having, yeah, management systems, yeah, which imposes certain obligations, yeah, which then at the end of the day has caused damage, has caused human rights violations, yeah. Just a step back, yeah, my starting point is basically, I take as a starting point English law for 2 reasons, basically, yeah. according to conflicts of laws, the English law, via the global spread of the common law system, is the most, influential one, the most applicable one, and also therefore, we have the richest body of a case law in this regard. But I also take references to other legal systems like the French system, US American case law, and also German case law, and academic debate. Okay, so the active role, this is basically in all legal orders, and we have a certain confirmation in the English case, the just mentioned case of Vedanta, that basically says, an unsafe system of production introduced by the parent, which may contain errors, would lead to liability. It has also been argued that the same could apply to an undue restriction of funds. Then the second level or step could be an assumption of responsibility, which could again be done in different ways, either a contractual or a de facto assumption of responsibility, or by law, which, for example, applies to expert liability. This has been argued in a number of cases, in the famous Chandler versus Cape case, in an West American, an older case, the so-called Amoco Cadiz case, in different German cases. And here, the most important relation now to due diligence is that in Vedanta, for example, due diligence instruments have been regarded as mechanisms for control and also an indication of control, and therefore an assumption of responsibility. Also, again, in two regards, either where, let's say, a management system has been introduced corporation-wide, but by doing so, the parent company has acted negligently, or by just promoting a respective responsibility which the company has not adhered to at the end of the day. So the very omission may constitute responsibility of a responsibility which the company has publicly undertaken to carry out. And then the third step, because this creates this certain contradiction, tension, that the first two approaches would only hold companies liable which have de facto taken responsibility somehow, as opposed to those which don't do anything. A legal duty to organize cooperation or supply chain wide systems so as to avoid damage, which can also be found in case law. There is this normative requirement of ought to have known in and ought to have done this and that in the Chandler ruling. That there are normative criteria in the Vedanta judgment, being based on expertise of the parent company and leverage, which could be carried out on the subsidiary or the supplier. And also in the case Begum versus Mahan, which is a ship breaking case, basically there has been imposed a downstream liability on the former ship owner. And with a view to the second aspect, the standard of care, we all know, we have the standard of a reasonable enterprise based upon which should have been foreseen and avoided. It's a normative standard, which nevertheless is, of course, based on the real conduct of existing enterprises, real due diligence systems applied in practice, which could create a minimum standard, which, however, does not lower the requirements for those particular companies, particular expert companies, for those who possess special knowledge and abilities. also in financial regards. Again, yeah, here human rights due diligence could impact in various regards. First, yeah, an individual human rights due diligence statement or guidelines or a management system basically reflects what the individual enterprise regards itself as foreseeable and avoidable, yeah, according to its experience and expertise, and could impact upon an individual standard of care. Sector specific, yeah, the already mentioned, yeah, industry systems, industry standards reflect what could be regarded as foreseeable and avoidable throughout a specific, the whole sector, yeah, which would impact upon, yeah, black sheep, which do not adhere to that sector specific standard. And the third is, yeah, but again, yeah, these only reflect minimum standards, yeah. Courts could go beyond and have to go beyond, yeah, in case these standards applied in practice are inadequately lax, outdated, or just inadequate in a given situation. Okay, so that's general tort law doctrine, yeah. Then when we look into the relation, or compare it to the UN guiding principles, we find a lot of parallels. Yeah, the foundation is basically the same. The assignment of responsibilities to third parties is sort of the same. The criteria are very comparable. Yeah, due diligence is very comparable to the duty of care. The duty to carry out comprehensive risk assessments, yeah, enhances foreseeability, yeah, the requirement to take preventive and mitigative action, yeah, refers to avoidability. It requires that within the whole system, that the responsibility has to be assigned to the appropriate level and function within the enterprise, which is basically the same for organizational duties. In tort law, yeah, there is a certain differentiation in both regimes, yeah, that the duties may vary, yeah, in proportionate to the size and the capacity of the company, criteria which also matter in tort law. Okay, so from that, basically taking from that as a basis, yeah, so the impact of the UN guiding principles on tort law, yeah, although they are expressly voluntary, but there is an arguable impact on tort law. So firstly, a direct impact on the duties, and to a certain extent also on the standard of care. Firstly, as they provide for an international consensus, yeah, it could be argued, yeah, that they reflect the respective relevant social norms and expectations, which are important in tort law for defining the reasonable enterprise standard. Yeah, and they, of course, yeah, they support or arguably even require a progressive recognition of duties of care towards suppliers and subsidiaries in tort law. And there is, again, famous case law in this now a Dutch case from the District Court of The Hague, the so-called Shell case, which is more famous in the arena of climate litigation, but it is also important here in this regard, yeah, because it has explicitly acknowledged the UN guiding principles as a global standard relevant in tort law, so a global standard of expected conduct for all business enterprises wherever they operated, and they deduced from them, and also from other soft law instruments, that it is universally endorsed that companies must respect human rights. And also they looked then upon the size of the Shell group and came to the conclusion that much can be expected from Royal Dutch Shell. And secondly, there is a indirect impact, basically through the inducement of due diligence. Yeah, the when guiding principles require voluntarily, but they use it, due diligence by the corporations. So following that requirement, you could argue that, yeah, leading companies, parent companies, take over responsibilities for certain management tasks. This could, in tort law, be an assumption of responsibility. At the same time, it thereby also concretizes, let's say, vague legal requirements, yeah, on how these organizational duties have to be carried out, and at the same time it concretizes the standards of care, and thereby, yeah, because we are in a in a forward-moving development, also raises a standards of care. And then last but not least, yeah, the impact of binding due diligence laws, which take totally different approaches towards the issue of liability, which is either remaining completely silent on the subject matter, like, for example, the Norwegian law does. Then, in principle, yeah, then we can only take a principled approach and say, yeah, we have a legal duty, yeah, we have a statutory duty to carry out due diligence requirements, which could either be qualified in tort law as a breach of a statutory duty, where the tort laws foresee that option, or as a breach of a duty of care under the tort of negligence, although without an explicit liability clause. Then we have the option that these laws explicitly rule out liability, which to a certain extent, not completely, is the case with the German law. So therefore, yeah, a breach of the legal due diligence duty is no breach of a statutory duty, and it also has no impact on the tort of negligence. Yeah, this is disputed, but I would say is the most convincing standpoint in this regard. So basically, we have no impact whatsoever. Tort law just would apply the general principles which I have outlined above. And then we have the last case, yeah, we have an explicit liability clause, which we have in the French law, and which is at least proposed in the European Sustainability Due Diligence Directive, yeah, which explicitly establishes legal duties of care. Yeah, with an explicit liability clause, which also regulates the overriding and mandatory application of French tort law, eased access to French courts, and which at least, yeah, provides the possibility, although it has not been taken neither by the French law nor by the European approach, to have rules on the burden of proof, because it is, yeah, as already been said, close to impossible to really, as a claimant, prove a causal link between insufficient due diligence and damage. So at least it would be a possibility to rule upon these procedural burdens. In all these sustainability laws, yeah, the liability clause has been the most disputed aspect of the whole thing, yeah, with fierce fights pro and against. So basically, yeah, the opponents argue that the liability clause would lead to enormous market disadvantages for the respective national or European companies, yeah, whereas the proponents argue, yeah, that it would be advantageous because it creates an increased legal certainty, yeah, as opposed to an unregulated situation where we are sort of trapped with unclear case law and with the need to apply foreign, in most cases, foreign tort law, which is also the results of which are also difficult to foresee. So to sum up, basically, yeah, tort law provides for elaborated criteria to impose corporate or supply chain-wide liability, depending on the facts of the case. However, yeah, traditionally, civil courts, yeah, influenced by the limited liability doctrine in company law, are reluctant to impose liability. This has changed only recently with a few case laws, has already been mentioned. The majority of them was only on procedural issues and not yet on the merits of the case. Hereby changed social norms and due diligence practices, as reflected and induced by the UN guiding principles, play a crucial role. And this applies the more so to the new supply chain laws, which could either codify direct duties of care or even direct liability rules, and also include provisions on applicable law, burden of proof, or access to justice. Thank you.
Well, thank you very much. That was just brilliant. I don't know if you want to, yes. That was really great. And you're bringing us back on schedule. Any questions for Lucas?
Yeah, of course, had to be, right? No, thank you, Carola, for a very, very interesting presentation. I don't actually think we don't overlap that much, but and actually mostly in agreement. So I think they're really, really well connected. And it's also good to hear a slightly more optimistic perspective as a contrast to my habitual pessimism. But I had two questions. I'd say one is because you spoke at length about the potential impact that the concept of human rights due diligence can already have on tort liability in a number of different ways. Do you think, because this was also, of course, the big discussion with the due diligence directive and also national law, do you think it is even necessary for a law to acknowledge that it's possible to use this as a standard of care or to use this to modify existing standards of care? Do you think it wasn't necessary? Because this is also something that I'm honestly still wondering, like, do we even need an explicit clause on this issue in any type of legislation, or should we just leave it alone? And two is, in terms of interpretation of the standards, I was wondering what your expectations are now that we have this human rights due diligence concept. Of course, the EU has tried to sort of make its own sort of version with its own sort of specific interpretations of the obligations. When interpreting like open norms of negligence, of wrongful act, as courts have already done, what is your expectation? Do you think they will also look towards the, you could say, human rights background of the UNGPs and UNGPs themselves? Or would you expect them to sort of stick with the particular legal instruments, such as the devoir de vigilance law or the due diligence law or its whatever implementation instrument? What would your, I know this is speculative, but I was wondering about your expectations.
Okay.
And if I can add a question, we'll do three, and maybe as people gather their own thoughts. So the last point you raised was actually the most interesting, and that is the reluctance in the common law states of piercing the corporate veil and preserving the asset partitioning of enterprises in civil law countries the same way. I'm wondering, though, why it isn't possible to shift tort liability from a direct relationship between the tort victim, the tort sufferer, and the company, and move it into the administrative realm. So, for example, one can always shift to a system of civil fines that would be undertaken by a regulatory authority, with respect to which a pot of money would be created in the form of finding that there's a violation, and that individuals who then had their rights damaged and can prove their damage would then appeal to the civil authorities for compensation. So you're no longer dealing with the issue in effect of asset partitioning and of the legal authority, the viability, the institutional autonomy of the enterprise is no longer an issue, because all of this is now mediated through an administrative apparatus in the form of civil fines that then go out. So that would just be my question. And we got 3, and then if there are some others, we can do another round and then end this part.
Okay, so the first question was basically whether we need an explicit clarification or something. According to my doctrinal approach, I would say clearly no. It is already inherent in tort law, so we just risk an interpretation as to the opposite. So, for example, with the German Lieferkettengesetz, there is this clause, does not create any liability rules, blah blah blah, but general tort law remains unaffected, something like that, yeah. And the discussions started, yeah. What does this mean, yeah? Does it even mean that tort law is no longer allowed to go beyond what the law says? Yeah, is it already a deviation from existing tort law principles? So what does that mean? So I think a proactive liability clause is always a good idea, but these clarifications, the tort law remains applicable, or tort law does this and that, I think this causes more confusion than it solves, because it is an intervention into tort law doctrine. Does this answer your question? What was the second question? Okay, that's speculative. I would say usually that tort courts love to have something real. So I would say, yeah, that they rather go for the concrete requirements instead of the more general aim of the UN guiding principles. But I don't know. Yeah, it's just speculation. And the third question, yeah, of course, that would be a good idea in principle, yeah, to have, yeah, as a solution to that problem with allocation of assets and so on. But it is not inherent in so many legal orders, yeah. We don't have in many legal orders, we don't have an administrative approach to private disputes or private private compensation. Yeah, I mean, the traditional way to do it is via private law, via tort law. This administrative approach is not that common.
It was a very naughty question, but thank you. Other questions? Claire.
Oh, thanks, Larry. Yeah, thanks, Carola. Great, very informative, dense presentation. I guess one question I have, since I approach this really as a primarily as a human rights lawyer and not a tort lawyer, is, or my question sort of derives from the fact that human rights in most of these discussions and harm to human rights is sort of assumed, and the relationship between tort law and harm to human rights is kind of assumed in the sense that it's not really interrogated very much or, problematized. Of course, there's some, important work ongoing in the scholarly community generally, around the extent to which tort remedies are available in order to provide a form of remediation for human rights violations within national constitutional orders, for example. But, in many of the discussions we have around, the relationship between due diligence and tort law, we just don't get very much, reflection on the nature of human rights being, essentially created at the international level rather than at the national level, the extent to which tort law constitutes any way an appropriate or meaningful remedy for different kinds of human rights harm. Human rights are not just a monolith. They comprise many different types of rights, different contexts, some things which might be amenable to tort-based remedies, some things where that's just not what the victim would want or would be appropriate. So, there's a great diversity there, which is not really questioned. It's just assumed to be a sort of monolithic, constant entity. So I just wondered on your, your reflections in that context here when we're, trying to, identify what's going on at this new interface between tort and human rights that's posed or provided by the due diligence legislation.
Thank you. Exactly. Of course, I mean, I left that out basically. Of course, that is the first step. But we have to compare, which human rights violation constitutes at the same time a tort. And of course, there is a broad overlap, but there is not, there is, of course, not a complete overlap. We have human rights violations which might not constitute a tort, or at least, those which are listed there. And we have torts which are not necessarily a human rights violation. Of course, that is the first step, of course, that this has to be clarified. We have to characterize what a type of violation do we have, and does this type of violation constitute also as a tort in the respective legal order. So for example, labor laws or things like that, an infringement of labor laws is not necessarily a tort, or things like, of course, we have to clarify that as a first step.
Lucas, last little point, and then we will close this out.
Yeah, just based on Claire's last question, maybe this is the infamous not a question but a comment. But just one thing, not in disagreement, but I think interesting to follow. I see oftentimes in these conversations, the Shell case gets cited, and for a lot of good reasons. I think it is in your presentation as well. But there's, of course, a fundamental difference between the Shell case and a lot of other cases that they weren't suing for damages. This was really, if you want to have a case which is in certain ways very much in line with the proactive job that human rights due diligence should have, that was what this was about. This was about litigating for a court order for Shell to improve its businesses. So this is much more, you could say, aligned with the direction of human rights due diligence. And it's not, and I know that Carola knows, of course. So this is not certainly not a critique, but something I find interesting to see whether or not this is even possible, sort of to do that retrospective view in a liability context, and indeed in a very more traditional tort context. So that was just I'd say an addition to your presentation.
Yeah, thank you. Of course, you're right, and that made it much easier for the court to apply this progressive approach.
Well, thank you very, very much. And I'm going to try to keep us on track. I will close out. I will try to keep this as short as possible. I want to end this session by bringing us back to the UN Guiding Principles, and let's see if I can do this. I think that will work. And just very briefly weave some of the more conceptual issues around which we've been speaking all morning, and then point to some of the additionally more equally interesting ideas that will be coming up this afternoon. And so just very briefly focus on the human rights due diligence in the UNGP, which will be the subject of my own contribution, but in a much more extended way. Just a little taste and a little closure here for the session. And of course, a lot of what we've been talking about all morning has been what I will call the problematique of the UN Guiding Principles itself, which has been the problematique of corporate social responsibility in the generation before, and about the nature of the essence of divisions between public and private spheres in modernity that has been an issue all over the world in one form or another over the last 200 or 300 years. And that is the way in which we align in the current era the public administrative apparatus with its own sensibilities and objectives and priorities with markets and institutions and their own sensibilities, priorities, and ways of doing this. So one of the ways in which we try to do it in the context of layering human rights as one of the values that ought to be necessarily embedded into the sensibilities of economic activity, both macro regulatory and operational, involve the coordination of states and enterprises, but also began the process of really rethinking, certainly over the last 20 or 30 years, of the relationships and transpositions of value, the notions of value in economic relations and duty in social relations. They're not necessarily the same thing, and it is the points at which they meet, collide, conflict, or align that much of both the opportunity and the issues and conflicts in the context of embedding human rights and sustainability in economic activity, and then doing this through the traditional mechanics of law now tend to arise. And of course, in this context, the three-pillar structure provides both the way in which one can look and understand this and the issues themselves. So the state duty to protect is grounded in public law, national constitutional law, state obligations under international law. Corporate responsibility to respect is grounded in markets and private law, guided by international norms to some extent, bounded by legal compliance principles within the territorial limits of state and national law, and then a remedial pillar in which the critical law of the state-based judicial mechanism is used as an overlay. That tends to be the way in which we've looked at this over the last number of years. And then that leads us to the questions, well, if this is what we're really trying to do, and this is in a sense how the UN Guiding Principles are set up, where does human rights due diligence fit into this framework, these alignments, these contradictions, these two large tectonic plates of organizing social relations in the public and private spheres work? And here, in this project, in my contribution, I look at the way in which these are sought to be woven together, both through the general principles of the UN Guiding Principles, and these general principles tend to be somewhat ignored, and also by using those in the elaboration of the end of the beginning narratives, which of course John Ruggie famously included in his 2011 report that introduced the final version of the UNGP. And the general principles are themselves, the general principles of the UN Guiding Principles are themselves critically important, because they themselves set a template that we sometimes forget about the interweaving of the public and private approaches of state duty on the one hand and corporate responsibility on the other, mediated through the hybridity of the remedial structures as we move forward. And of course, we look at it in the same context. The danger of doing all of this is the ever-present and sometimes growing temptation to revert to bad habits in the past. We have three pillars, the temptation to reduce them to three quite distinct regulatory silos, with ambassadors going back and forth, metaphorical ambassadors going forth. It's sometimes irresistible. the use of these regulatory silos to create risk cabining, risk in the public sector as opposed to risk in the private sector, as opposed to risk within judicial mechanisms, is also sometimes irresistible. And these tend, when they're blended in, they tend to both obscure and to make the issue of human rights due diligence in general and the application of a human rights due diligence across the public and private sector and operationalized, at least with respect to human rights holders, through the judicial process. It makes it more difficult. And yet it is worthwhile to spend a little bit of time remembering and perhaps ultimately privileging the interlinkages, both the structural and regulatory interlinkages between the two. And to that end, one can, this is my little section, crossing the streams and fording the rivers, looking at the way in which the elements of human rights, of due diligence in general and human rights due diligence in particular, bridge these regulatory pillar silos and can be used to kind of get perhaps a richer and ultimately perhaps more effective both regulatory and market structures. And again, when we're talking about due diligence and risk, and I started at our session by a nod in this direction, we're looking at processes. Due diligence is not its product, but it's the process of getting to its product, or actually a shelf full of products. It's a process or an effort to collect and analyze information before making a decision. So we're not looking at norms in a sense. We're looking at a modality, a method, but we're looking at a method that is grounded in data, which is itself a particularly troublesome thing. What data? How do you recognize it? And all of which then ultimately has to be informed by the normative framework and then the objectives that can be derived from the normative framework with respect to which due diligence is then applied. In the context of economic activity, of course, we're dealing with due diligence to mitigate or prevent or remedy risk. But risk itself, like the UN guiding principles, like virtually all human social collective activities, tends to be siloed in a variety of different ways, each of which having its own regulatory and disciplinary structures. I put the most common ones up on this slide. Legal risk, of course, of particular interest to the lawyers among us, and Birgit did a really nice job in describing the consequential effects of legal risk, both on the enterprises and on the gatekeepers, the lawyers that then service them. Business risk, of course, financial risk, which has been a particular focus of the UN working group, for example, the last couple of years. Compliance risk, which is something new and something that bridges both the public and private spheres. And for the state, unlike the business, where businesses focus on business risk, the state, we never really talk about due diligence within and as part of the public sector, but there's a significant political risk as well, something that has been understudied and perhaps something that needs a little bit more work. And all of this, of course, underlying the notions of due care with respect to all phases of economic activity, with respect to internal valuation and external impact, with respect to the costing of operation, right? And with respect to teasing out where this will have effects that touch not necessarily on the economic activity itself, but on the public functions of the state in general, and then the economic community, the international community in general, with respect to their own spheres of objectives, responsibilities, and duties. So it gets sort of complicated. I figured it's late in the day. I put up a picture of my dog to kind of give you a moment of pause. But all of this, of course, suggests the risk regulatory structures that are inherent in the UN Guiding Principles themselves, and in the way in which one perhaps ought to read the pillars 1, 2, and 3 as both interlinked and interpenetrating institutional frameworks that, in order to make human rights due diligence work, must be understood not as individual structural silos from out of which one can transpose and borrow, but that indeed one cannot fully appreciate any of these pillars without understanding its interpenetration with the other two. But then that causes some problems. I've mentioned, I note in this slide a couple of them that are specific to the particular pillars. When you're looking at due diligence, especially in the notion of interpenetration, you have due diligence in the context of the state duty in the form of macro regulation, in the form of coordination, all of which requires due diligence, and in their guidance function within their territories and the enterprises that they control. The supra coordination through international institutions and private actors as well. All of this requires due diligence and due diligence systems that are critical for the proper functioning of the micro regulation and the micro diligence that we tend to focus on in quote unquote human rights due diligence, and then mandatory human rights due diligence, which has its origins in the second pillar. So we go from macro regulation and macro diligence of a public character in pillar 1 as a necessary foundation and constraining set of templates to make it possible to realize, even as on a legal basis, the micro regulation, fundamentally private, but through compliance regimes and administrative management, also having a public character, the micro regulation of the economic activity itself, involving coordination, guidance functions within the territories here, not of the state, right? But we have micro regulation within the second pillar in the territories of global production, and that creates the usual governance disjunctions between macro regulation in Germany and the operations of Volkswagen, which tends to be all over the place, which then has its unified regulatory characteristics run through Volkswagen, not through Germany, but with respect to which Germany, China, and others can intervene. And again, supra coordination here, not through international institutions and private actors, but through NGOs, international organizations, and states. And then, of course, the third pillar, which is a state-coordinated system of interlocking remedial mechanisms, and not just judicial in the sense, but we mentioned earlier in the day, arbitration in other forms. And so when you begin to see the notion, the project of due diligence in general, due diligence tied to risk, and risk due diligence in the context of an overarching normative structure, in this case, human rights and sustainability, including climate change, and then you re-embed that within the operational assignment of parts of this thing through the three pillars, you begin to see how this machine or this structure actually can set up and operate, and a hyper-focus on any one of these will tend to distort the ability to create a seamlessly running system, at least as this thing was considered at the time that we do this. And of course, the overarching objectives, we've talked about this over the course of the morning, is prevent, mitigate, and remedy, which is itself highly problematic in a sense. You're transposing prevention, mitigation, remedy, transposes public, administrative, cultural sensibilities, embedding accountability. It avoids free riding, but it governs risk and values in business decision making, but also, which is an endogenous function, but it's also exogenous by imposing conduct rules and interdictions. The two of them sometimes align, but not always, right? And that brings me, I know I really do want to end at 12:30. I'm getting close. And that brings us, in a sense, when you describe this large, complicated, abstract machine, to the central contradiction within the human rights due diligence. It's really human rights and sustainability due diligence between the two spheres whose alignment remains problematic. Right. And the first is, of course, markets, which is based on bottom-up decision-making rather than management, which is centrally planned or top-down. With respect to markets, we're looking at issues of line drawing. Post facto compensation tends to be privileged. The longer term, one can consider systems of mitigation, and in the longest term, prevention, where prevention is more valuable in terms of the production of value for the company than periodic compensation as things go bad. In a sense, it can be viewed as a quality control issue, and it can be viewed as a cost of business in the context of the amount of quality control that one has to put in. The mental orientation will be very different, right, than the mental orientation of an administrative system, of an administrative bureaucracy grounded in the sensibilities of public law, right? And again, that is in part driven by the ideology and construction of profit, right? In the markets oriented is private profit. In the public orientation is public profit. In the context we like to call it public goods or public value, but it's profit all the same. And then you contrast this, of course, with the management compliance based on the state as the critical shareholder. And here you're centralizing or privatizing standards and standard setting functions in ways that shift the focus of value and value production from the key internal and actors within a collective economic enterprise to the key external actors of the regulatory environment in which these entities are allowed to function. And so we move from in this context, the embedded in all of this is we move into John Ruggie's famous and to still today fairly controversial notions of principled pragmatism, and then into human rights due diligence. This I quoted from John's 2006 and 2007 reports, again, where he sets this up in 2006, that companies are constrained not only by legal standards, but social norms and moral considerations, all of which have standards, all of which are built into human rights due diligence. And then the state, this is a 2007 report, has a duty to protect against non-state abuses. This part is a key part of its regulatory regime, requiring regulation of abuse. The alignment between regulation of abuse as part of the state duty in the 2007 report and the development of standards for conduct in the 2006 report for companies don't often align. And with that, I will go into goals and structures, but I will leave that for another day. And I hope that that provides at least a small basis, both for setting our discussions today in a larger picture and for setting us up for the what I expect to be absolutely brilliant contributions this afternoon. And with that, I am done. And you all have been great in hanging here with us all of this time. I don't know if there's a question. I'm happy to entertain one, but otherwise I can bid you all either good evening, good morning, or enjoy your lunch. Excellent, excellent. We will pick up again a little before 3. I think it's 2:45. Claire will introduce us all and take us through the afternoon session. Again, thank you all, participants and attendees. Absolutely brilliant. I really appreciate all of this. It is marvelous to be in a community like this one. And thank you for helping in your own ways to make the world a better place. And with that, I will see you all this afternoon.